So Bernard Brinson is the individual who said that he heard this confession, and that's a separate individual than the victims in the case.
Brinson, who said he wasn't cooperating, and if he was called to the stand, he would tank the case?
No,
that's
a different person.
Bernard Brinson is the jailhouse informant who told the police that the person didn't confess to him.
Right, and who was given a polygraph that he passed.
Which is also...
Let's take a moment to break this down. The entire debate centers on a jailhouse informant, someone in custody who claims another inmate admitted to a crime. Courts treat this type of testimony with caution because these witnesses often expect something in return, such as a reduced sentence or special treatment. When you add a polygraph test, which most courts do not consider reliable evidence, the argument becomes even weaker.
Inadmissible. So all of this, I know we're rehashing it.
Yeah, and Segovia followed up and investigated.
Right.
Well, when Detective Segovia said that, it probably just, there are these jailhouse snitches who have something to gain and are
He
not
wasn't the only
credible
one, right?
And can't be relied upon. At that point, the fact that a polygraph was given and he passed that polygraph should have been used to impeach.
Right. It's not impeachable. It's inadmissible evidence, and I excluded it just like I excluded the jailhouse snitch who said that the defendant confessed to him that he had committed this crime. So, you can't use hearsay on one side and not the other. And the snitch from the jailhouse who's giving a statement made allegedly by the defendant would be admissible because it's by a party opponent. It's not in the inverse.
That's why the judge quickly moves to limit this line of discussion. The defense argues that the rules must apply equally to both sides. If one party is not allowed to use hearsay, the other side shouldn't be allowed to use it either. The standard doesn't change depending on who benefits. Evidence is either admissible or it's not.
There's a reason the state did not call that person, Judge, and the rules apply differently when it's the defendant's right. That's the defendant's
The rules of evidence do not apply differently.
The state could have called that witness. Just for this record, it is very clear. The state could have called this witness. We had him being transported from federal prison in July. The trial date got moved in July, and we canceled that. We ultimately made a strategic decision not to call him. There was voluminous discovery that we were disclosing to the defense, and there were other reasons we chose not to use him. But
fairness is the foundation of any trial. At one point, the prosecution admits they could have brought the informant to testify, but chose not to. That decision often signals concern. Jailhouse informants can be risky witnesses because juries tend to question their credibility.
we could have called him. The defendant's confession to him had things that only someone who committed this crime would know. There are things that we could guess that were supported by the evidence that explained things that the evidence we had, it explained like exactly what had happened, and it was very credible on its face. There are other issues and reasons we chose not to use it.
A lot of issues involved with that jailhouse snitch. Information that was fed to him by Detective Segovia.
Excuse me?
Yes.
Where? Based on what?
Indeed.
Okay, this is...
Wait, stop. Ms. Peabody, I'd like to hear what that information is because I haven't been made aware.
If you look at the statement itself, everything that he said in there, those things that he said, was all information that the police had and was given to him. Everything that the police wanted him to say.
Where is that? Wait. Just a second, Ms. Peabody. I've noticed that you're a little upset about it, so I'd like to give you an opportunity since we're proffering for the record.
Okay, so since we're proffering for the record, Your Honor,
I haven't finished my sentence. I am addressing you, and I do want to hear from you. You're saying that the information that this witness brought to the police was information that the police fed to him first, and what are you basing that on? And just tell me what it is.
Because of the nature of the questions that were given by Detective Segovia to this witness in his statement, it's clear that that information, even in where he lived, where he was born, he was born,
where the defendant or
the jailhouse snitch said in a different place than he actually was born.
And that was honestly more credible to the state because the defendant had been living in
Just a second. So you're saying that the police officer you fed The police officer fed the jailhouse snitch the wrong place where the defendant was born?
Yeah, that's what she just said.
Is that,
Your Honor, what I'm saying here now is this. The state keeps saying, and the court keeps saying, we could have brought in this witness. If you could have brought him in, bring him in. Nobody stopped you from bringing him in. But to say now that you didn't bring him in for strategic reasons, that's your decision. That's your decision.
Okay,
hang on a second.
litigating this.
Hang on a second. I don't know, the state made a reference to this witness. I made a reference that we're talking about snitches and their reliability. Both sides did not bring in snitches because of a whole bunch of issues. Ms. Peabody indicated something that I think is very important to flesh out, and I would like to gather the information. If the allegation is being made that a detective has fed information to a jailhouse snitch, I would like to have it proffered on the...
One inconsistency or false statement can seriously weaken a case. The situation escalates when the defense suggests that police may have shared details with the informant. That is a serious accusation of misconduct. The judge immediately asks for clear information on the record because, if proven true, it could significantly damage the prosecution's case.
So it can be investigated. I think it deserves I haven't finished. I think it deserves attention. What I've heard thus far is that the police officer told the jailhouse snitch that the defendant was born someplace other than where the defendant was born.
No, that's not what I said, Your Honor.
Okay.
I said that the information that he had was different than the truth. I also said that it is clear in the questions that Detective Segovia gave him that this was information that came from the police reports and not information.
Please give
that he
me an
got.
example so that we can follow up on this.
Okay, if you give me an opportunity to get to the statement, I will.
Yes.
Can we respond?
I would add,
Sure.
there are two things I would add. One is, when we look at the George Jones confession, since the allegation is that the detective was feeding information, one of the things that the defendant tells George Jones, in particular,
Are we litigating this one now?
he gets suspended from the team. He couldn't face his mother. He couldn't face his family back in Ocala. He had gotten, I guess, the coach thing was Randy Shannon had basically told him he was never going to play again at the University of Miami, and his life, as he said, was done. There are at least three jail calls. I know because I listened to
which part of that was
them. One in
done?
specific. One in
Part of that
specific
was
is a
done.
jail.
Ms. Peabody, please stop interrupting everyone. I'll give you an opportunity when it's appropriate.
One
You
in
can finish.
specific is a jailhouse call in which he's talking to a male friend, where he talks about the fact that he had a conversation with Randy Shannon, and Randy Shannon told him that he was done on the team. There is another jail call that I have between the defendant and his wife, one in particular where he said...
Okay, just a second. Ms. Peabody said that's not true. At the end of this trial,
I'm going to send them right now.
I'd like
I
to
have the
pull it up,
transcript.
so, because I'm hearing things saying that's not true.
The jail calls have already been provided to the defense.
I know.
Those three in particular, the other two that I've referenced previously is one where the defendant is speaking directly to his wife, where he tells his wife, here's the phone number, 786, to attorney Michael Cohen, because he would like, George Jones would like a Rule 3 filed for him. Michael Cohen, who did represent George Jones. And there's another call from the wife yelling at her husband, back to the defendant, saying, why would you have given George Jones my information? Why would you have done this? Why would you have connected us together? Why would you have told him personal information about me? The fact that I live in Ocala. So let's just be abundantly clear that while the allegation is that the detective is allegedly slinging stuff, the defendant is the one who made the comments to George Jones, and there are jail calls that back up what he tells.
The state argues that recorded jail calls support the informant's claims. The defense strongly disagrees, pointing out that speaking with family, contacting a lawyer, or sharing phone numbers does not equal a confession. The key issue is simple. Does this evidence truly prove guilt, or does it just create suspicion?
In support of what he tells George Jones. In addition to the fact that he goes to Miami Beach that night, he throws the firearm over the causeway and into the ocean. That is in the George Jones statement.
Okay, why didn't you bring that? Why didn't you bring that?
That's all.
What I don't need to add. That's how they decided to prosecute. Hey, hang on a second. Just a second. You seem to be very riled up about this defense. The allegations that are being made are being refuted by the state, saying they're in the jail calls, of which Ms. Peabody asked a lot of times for me to ask the state to tell her which calls were going to be referred to, because there were over 400 calls and she hadn't gone through them. So I'm going to give her the benefit of the doubt that maybe she hasn't heard those calls and was making this allegation because she wasn't aware that they were in existence. Is that wrong, Ms. Peabody? Are you aware of those calls and still making this accusation, or what maybe not?
I have not heard that call, Your
Okay.
Honor, but I will tell you this. What the prosecutor has just said does not equal to a confession. She's talking about innocent things there. The wife called to an attorney for somebody to get a bond, and for the wife to say, don't give my number. How does that equal a confession?
Well, I think what she was
So if you're saying that this is what George Jones brought to say that that was a confession, there's no confession.
No. That statement wasn't the confession part. That statement was to corroborate the information that would only... I haven't finished. That would only be known to this person, that the detective could not have known, and it is corroborated by the testimony I'm not finished, on the call from the defendant. So the defendant is making these statements with his wife on a phone call, and the person who's giving the information to Segovia is repeating it. So he could only have known it from the defendant.
Your Honor, the call is not the statement. The statement is completely different from the call.
Yes.
And that's what I am saying. The statement is what my concern was. And as far as the causeway is concerned, when I go across the causeway, not only is there an embankment, but there are trees. And there are video cameras. So if that were the case, then the state should have brought in the video tapes up.
Hang on. In 2006, when you drove across the causeway...
They're the ones that brought the prosecution, Your Honor.
Right, but you're
They're the ones that had it in 2006 or 2007.
Ms. Peabody, you're making statements that are so frivolous and out of the realm of reality. Because in 2006, we know that there were not cameras there. And on the causeway, the entire causeway is not blocked.
I don't know that. It wasn't brought in evidence.
By
How do we know?
It's pretty much common sense.
It's not really, Judge, because I've been here all my life.
All right.
I think we need to finish proffering so that we can have the jury
Well, just a
deliberate.
second. I am going to decide who's going to finish proffering. I understand that's what you'd like to do. Let me make the decision. That's why I'm sitting here. Secondly, the reality is the state has talked about this statement, and I think the defense is getting a little agitated because the context of the statement has never been discussed in the courtroom. And I think it's only fair when the attack is made that the detective is feeding information, that the state be able to put this information on the record, just like I'm allowing the defense to proffer things on the record. And when accusations are being made about the detective, which can be backed up by phone calls that maybe the defense isn't aware of or haven't had the opportunity to review or have decided not to review, they can put this information on the record. It is fair for both sides. I am letting you all speak much more than any other place would, or any other court, because I realize that emotions are very high. It makes no difference to me what the confession part that's alleged to have been made, which everybody is more privy to than I am, because I've never heard it or read it. I understand that it wasn't admitted into evidence, so I frankly don't really care. The part that I care about is if there is an accusation that a police officer was doing something that was inappropriate, like feeding information, which I have still yet to hear what that information might have been. That is something that I'm interested in.
The judge makes his position clear. Decisions will be based on facts, not emotions or rumors. What matters most is whether proper procedures were followed and whether any official acted improperly.
Because that's a whole other topic.
It was
And Your Honor,
twofold why the
also
state was
brought
responding.
to attention other
May I-
things that Detective Segovia has done that was improper, like outside the courtroom and threatening a witness.
Oh,
Ms. Peabody?
Don't say things you weren't present for and don't have any evidence of.
All right. I'm gonna call liaison. Ms. Peabody. Ms. Peabody. Maybe we should take a 5-minute break so that she can take a breath. Everyone out. Everyone out. Yes, everyone out, including you. Out. Out. Unbelievable.
All right.
This case is about more than one witness. It raises bigger questions about credibility, police conduct, and fairness in court. In the end, it comes down to trust. Should a person's freedom rely on the word of a jailhouse informant? Share your thoughts below.